Welcome to my presentation on Arabica and Batuna, when treaty law meets environmental reality. Today, we will explore how treaty suspension, environmental obligations, and jus cogens norms collide in international law, guided by the Vienna Convention on the Law of Treaties. Once upon a time, two neighboring countries, Arabica and Batuna, decided to work together. They signed a treaty to build and manage a dam on their shared river. Things started off well: cooperation, development, and shared goals. But over time, the situation changed. Arabica grew frustrated. They claimed Batuna wasn't following the environmental rules set in the treaty. So, without any negotiation, Arabica suspended the agreement. Batuna didn't agree. They said climate change made the rules outdated and even argued that the treaty conflicted with the human right to access to clean water. And so, what started as cooperation turned into conflict, but was Arabica allowed to walk away? Were Batuna's defenses valid? Let's delve in further. State Arabica and State Batuna entered a bilateral treaty to jointly manage a dam on their shared river. A decade later, Arabica unilaterally suspended the treaty, claiming Batuna had materially breached it by repeatedly violating environmental safeguards, which are treaty obligations. Batuna denies the breach. It argues that the safeguards are outdated due to climate change and invokes the principle of rebus sic stantibus, a fundamental change of circumstances. Further complicating things, Batuna invokes a UN General Assembly resolution that recognizes access to clean water as jus cogens norms, suggesting that the dam's river waters diversion now violates pre-emptory international law. In this presentation, we analyze the legality of Arabica's suspension and evaluate Batuna's defenses using the Vienna Convention on Law of Treaties, or known as the VCLT. International law has rules about how treaties work. One of the biggest: states must follow what they agree to. That's called pacta sunt servanda. But there are exceptions. If one side seriously breaks the rules, or if something big and unexpected happens, like climate change, there may be reasons to leave the deal. Some even argue that access to clean water is a human right that overrides treaties. But are these agreements and arguments strong enough? Let's find out. The backbone of treaty law is pacta sunt servanda, found in Article 26 of the VCLT. This means that treaties are binding and must be performed in good faith. States cannot disregard their treaty obligations unless justified by international law. The principle supports stability in international relations. The Namibia adversary opinion by the ICJ emphasized that termination or suspension must meet legal thresholds, not political convenience. Thus, Arabica must demonstrate that its suspension is not a political decision, but one grounded in lawful exceptions. Article 60, subsection 3b of the VCLT: a material breach is a violation of a provision essential to achieving the treaty's main goal and purpose. If proven, the other party has the right to suspend the treaty. Arabica claims Batuna's repeated failure to uphold environmental safeguards amount to a material breach. However, proving this isn't straightforward. The safeguards must be essential, not peripheral. We can analyze this with the Gabčíkov-Nagy-Maros project in 1997, where Hungary unilaterally suspended a joint dam project with Slovakia, citing environmental threats. The ICJ, however, rejected the claim, ruling the suspension was unlawful and disproportionate. Similarly, unless Arabica shows that environmental protections were central to the treaty's object, and that Batuna's breach was serious and persistent, its unilateral suspension likely violates the VCLT. Batuna's defense rests partly on Article 62 of the VCLT, which allows for treaty termination when there's a fundamental unforeseen change in circumstance that radically alters obligations. Climate change on the face may seem fit. However, International courts interpret this article very, very narrowly. In Gapki-Voko, the ICJ found that the change in the Danube River's water flow and environmental conditions did not meet Article 62's high threshold. The court emphasized that treaties must withstand the test of time unless the change fundamentally destroys the treaty's foundation. For Betunia to succeed, it must show that climate change has drastically transformed the environmental baseline in the way that makes compliance with the original safeguards impossible, not merely inconvenient. But climate change, despite its urgency, is increasingly seen as foreseeable, weakening the claim of unforeseeable circumstances. Additionally, Betunia also argues that the dam's water diversion violates jus cogens, or preemptory norms that are recognized under international law in Article 53 and 64 of the VCLT. A jus cogens is a rule accepted and recognized by the international community as one from which no derogation is permitted, like prohibitions against genocide and slavery. Article 64 says if a new jus cogens norm emerges, any existing treaty in conflict with it becomes void. Therefore, Betunia relies on UN General Assembly Resolution 64292, which recognizes access to clean water as a human right. While resolutions are not binding, they can signal emerging customary norms. But for a norm to be jus cogens, there must be near universal and consistent state practice and opinio juris. As of now, environmental protection and water access, while morally compelling, do not yet meet the standard. Thus, while Betunia's argument may reflect future directions in international law, it lacks current legal force under the VCLT. Ramika says Betunia broke the treaty by ignoring environmental rules. That sounds serious, but is it enough to walk away from legal agreement? Betunia argues the world has changed. Climate change has made all rules unfair. They also say that the treaty blocks people's access to clean water, which they believe is a basic human right. Now, we're stuck between two big questions. Is Aramika's suspension legal, or do Betunia's defenses hold up? It's up to the judge right now. Let's break it down. Aramika's actions also faces legal hurdles. First, it did not pursue dispute resolution as expected under treaty law and general international practices. Second, the material breach threshold under Article 60 is not easily met, and unilateral suspension is viewed cautiously in cases involving bilateral cooperation projects, especially where mutual reliance is high. A lawful road would have been initiating proceedings, maybe towards arbitration or submission to the ICJ. The principle of peaceful settlement of disputes, embedded in both the UN Charter and the VCLT preamble, supports this approach. Betunia's defenses are ambitious but flawed. Rebus Sic Stantibus is rarely successful due to its narrow application. The ICJ's case law suggests that treaty obligations are expected to withstand substantial external changes. The jus cogens argument may be persuasive in human rights circles, but legally it's premature. The ICJ judgment has yet recognized environmental rights or water access as jus cogens. Still, Betunia raises a valid point where treaty law needs to evolve to reflect new realities like climate change and environmental justice. Instead of walking away, Aramika could have taken the case to court or found a peaceful way to solve the problem. Betunia could have asked to update the treaty, maybe even adding in new climate rules. In the future, treaties should include review dates as well as flexible rules so they don't break when the world changes every so often. Moving on to recommendations. For Aramika, seek peaceful resolution mechanisms rather than unilateral suspension. Use Article 33 of the UN Charter, either mediation, negotiation, or judicial settlement to resolve disputes. For Betunia, consider proposing an amendment under Article 39 of the VCLT. This allows parties to renegotiate treaty terms. This would enable an update of environmental safeguards to reflect current scientific realities. More broadly speaking, states should include climate adaptation clauses in future treaties. Treaties must be living instruments, resilient and responsive to global changes. In conclusion, State Aramaica's unilateral suspension of the treaty was legally unjustified. Under Article 60 of the Vienna Convention, it failed to prove that Botunia's conduct amounted to a material breach of an essential treaty provision. Environmental safeguards may be important, but without concrete, sustained violations, suspension is a disproportionate response. As for Botunia, its reliance on Article 62, Rebus 6 centibus, is also unconvincing. While climate change is a pressing reality, international law does not yet accept it as unforeseen or radical transformation sufficient to terminate treaty obligations. Additionally, Botunia's jus cogens argument also falls short. Although access to clean water is increasingly viewed as a fundamental right, it has yet to achieve the legal status of a preemptory norm under international law. Thus, Article 64 does not apply.